My Lords, good morning. My Lords, I appear in this matter together with Mr. Ian Benjamin on behalf of the appellants, and my learned friends, Mr. Gavin Keeley, QC, and Miss Elizabeth Lindsay, appear for the respondents. My Lords, you have seen there are two appeals in this matter, one against the judgment of the Court of Appeal on what was being called the main appeal on liability quantum, given on the 3rd of February 2015. We call that the main appeal. And the other is against the judgment of the Court of Appeal given on the 24th of July 2015 in relation to GAM's application to enforce against Victoria Square.
Victoria Square, yes.
My Lords, I appear in the first appeal, and I shall be dealing with that exclusively, and my learned friend Mr. Benjamin will be appearing on the second appeal, the Victoria Square appeal, and
yes,
dealing with that exclusively. My Lords, you should have received a very short, small supplementary bundle the other day, which contains one document which was in fact referred to in the evidence and indeed in our written case, but which we hadn't been able to find when the record was compiled.
Yes.
And that is at page 2400.
Yes.
2400. I don't know if it's got into the electronic record or not. But it's got an electronic bundle page number. I don't suppose that's necessarily reliable. But this is an email written by my clients at halfway down the page on the 11th of December, Mr. Ramdean, where she says, I've got good news for you, or I hope it is at least, where she basically says, I've decided not to stick with the RBBT, the Republic Bank, the Royal Bank of Trinidad, and then there's a short reply. This was referred to in our written case, but we hadn't been able to find it at the time. So we've exhibited it here. And then there are further documents, one or two, which are relevant to the Victoria Square appeal, essentially documents from the enforcement proceedings over Heveron Heights, as opposed to Victoria Square, which were heard, I'm told, initially all at the same time as the Victoria Square hearing at first instance. But it's just a short fixed date claim form and an affidavit. My Lords, we don't apprehend there's any objection from the respondents to the addition of these two or these documents to the appeal bundle. But if there is, we'll hear, no doubt. No doubt hear in due course.
They were there below.
My Lords, on the main appeal, my client's position is in essence as follows, that GAM had a lending limit, whether in law or in practice, which prevented it, at least in practice, from lending substantially more than $18.6 million, which it did lend to my clients in September 2007. Further, its failure to mention this limit distorted its positive representations about the differences between itself and banks or large banks, whichever representation one looks at. And I say, so far as it is material, the board should prefer, for reasons I shall come to, the representation alleged by my client as opposed to the representation alleged by GAM. But our primary position is it doesn't make any difference. And we say, as a result, we entered into the loan agreements in September 2007, and we say, on that basis, we have a claim both under the Misrepresentation Act and in negligent misstatement.
What do you say you would have done?
We would have gone somewhere else. We would have gone to a financier. I was going to come to that. We would have gone to a financier who was in a position, who would have been in a position throughout 2007 and 2008 to increase our facility by another $6 or $10 million, which is what we needed.
But without any undertaking or representation that they would?
No, we accept that GAM did not make a representation that it would finance the project.
But it didn't say that it wouldn't.
Didn't say that it wouldn't, but it said, our point is, we were led to believe that it could. Now, had we learned that it couldn't, we would have said, well, thank you very much, we'll find someone who is in a position not only to give us the money we need now, but who will be in a position in due course to fund the further project.
Did you give evidence to that effect?
Oh yes. That was very much
look at that.
the evidence. Yes, I'll come to that, yes. And that was definitely our case. It fell into two parts. First, we would not have gone to GAM in the first place to get a loan, had we been told of that limit on its lending abilities. Second, even after the loan agreement had been entered into, we say the position was still material in 2008, especially July 2008, when indeed we were thinking of going somewhere else, and we did indeed talk to another bank from that point to November 2008. But even then, the limit wasn't mentioned.
You say from November 2008? It was...
November 2008 was when we actually had another bank lined up.
Yeah.
But eventually there were some, they were being slow, putting it shortly. And so we decided, oh, well, we may as well stick with GAM. Now, our point is that had we been told any time between July and November 2008, look, there's no way we can lend you more money, then we would have committed ourselves to that other bank, or indeed another bank. Instead of which we find ourselves in the position at the end of 2008 without another lender. And then in 2009, January 2009, GAM says, oh, we've got a problem because of our limit. I'll come to this in a moment. There's then an attempt to sort things out.
Well, the market then crashes.
Then the market crashes at the end of January 2009. And at that point, we're stuck.
Has the Court of Appeal held that that was a novus actus interveniens?
Well, not quite sure, but they've held it's they've basically said it's all irrecoverable.
Right.
Outside the scope of the duty, that type of argument. But my lord, I'll come, if I may, to those arguments in due course. But that's what we say. We say we were misled into A, doing the deal with GAM in the first place because of the failure to mention the lending limits, and B, even afterwards, we were misled into staying with GAM at a time when we could, indeed, were thinking of going to another bank. But we decided not to. So that's the reliance. And we say, as a result of that, we are in a position where we have sustained loss because we did not get the financing, which at least we had the opportunity of getting from another financier in 2007 to 2008, which would not have had the similar problems which eventually...
So what's the measure of your loss on that basis? Is it the chance of getting a...
Exactly.
So has anyone assessed your chances?
No, not yet. My lord, what we say is if you find with us on liability, we don't invite you at this stage, and we take the same approach as we did in the Court of Appeal. We don't say that the board in this case should, as it were, take it on itself to assess the loss, certainly not. We do say if you are with us on liability, then the matter should be remitted to a judge to decide what the losses were which followed.
Did you assert a loss of a chance in front of the judge?
Well, we didn't assert loss of a chance, we just asserted a loss. Yes.
No, but you asserted loss on the basis of a promise that there was an undertaking by GAM to provide the finance, which didn't meant that the judge didn't need to consider.
Well, my lords, not quite. The loss was, the loss asserted, I'll come to this in due course, was asserted on either basis. When you look at the pleadings, essentially the case was run on two bases. You misled me into believing that you could finance the whole thing, basis number one, and basis number two was you promised me you would finance the whole thing, or at least misled me into believing you would finance the whole thing. They were the two different cases. I'll come to the pleadings, but they're quite clearly different cases. And the loss was pleaded as resulting, if I may put it this way, from both, or either.
But the loss that was pleaded was the whole loss, wasn't it?
Well, it would be, because our cases, we could have got financing from somewhere else.
Where's the alternative claim for loss of a chance?
Well, my lords, we don't plead it as loss of a chance, but what we do say is, we simply say, we have lost all this money as a result of being misled into staying with GAM, going with GAM and staying with GAM. Had we not been, we would have got finance for the whole thing, and therefore we wouldn't be in this pickle at all.
How much finance did you plead that you needed?
Well, my lords, I don't know if it's pleaded that we needed any particular extra sum, but on the facts, we initially asked for $6 million, and that was, I think I'm right in saying, at the end of December 2008 and early 2009. And it was in response to that request that GAM said, no can do. That if we had a bigger capital base, we'd be able to do it.
I mean, you say that $6 million would have done the trick.
Well, it certainly would have gone a long way to doing the trick, because we needed that to pay off partly to pay off existing suppliers, also to carry out what are called finishes.
But let us suppose that things looked a bit grim generally, as from January 2009. and that interest in the property began to dry up. To complete it, the total cost seems to be somewhere around 60 million. Were you saying that it was going to be possible to get alternative finance for anything in those circumstances?
Well, absolutely. One of the problems was purchasers began to pull out or ask for their money back. What had happened is purchasers paid their deposits.
Yeah.
The problem is if the project is stalled, but you're not going to get the purchaser to pay anything else on top, right, while nothing's happening.
Which means you needed more money. Now, what was the evidence? Well, you're going to take us
Yes.
some stage, are you, Mr. Knox, to the evidence that you led
Yes.
to demonstrate that if what you say was a misrepresentation had not been made,
Yes.
you would have had the money available from somewhere else.
Well, my lord, I will certainly take you to the evidence that we would have gone to RBBT.
No, that's not what I asked.
Well, who were prepared
Are
to
you going
finance
to take
it.
us to the evidence? Was there any evidence? Just yes or no?
Yes, but there was evidence from Mrs.
Could have got it
Deslauriers.
somewhere else.
No, there was evidence from Mrs. Deslauriers that she herself would have stuck with RBBT in November 2008, who had offered to provide further financing. I'll take you to it, but that's about as far as it goes.
That's how it's put, anyway. Yep.
But my lords, I submit in any event, if your lordships are with me on liability, it would be quite wrong to shut out an inquiry as to the loss that has flowed from the misrepresentation. If, my lords, you accept reliance. I accept if there's no reliance, then that's that. But if the position is A, we were misled, B, we relied on the misrepresentations alleged, then C, I submit it must be a case for assessing the damages which result from that.
Well, I think one of the points made against you is you've got to show, in order to say you were misled, that there was a representation which is capable of giving rise to liability, in other words, on which you as a reasonable person could have been expected to rely.
Yes.
And you will have to look quite closely at the emails and see what was said.
Yes, absolutely. My lords, I certainly will be taking to that, if I may. I'm conscious of the time, and I'm going to have to deal with it to a certain extent on a fairly summary basis.
So
because
you've dealt with it in great detail. You've dealt with it in great detail in your cases, both of you. Yeah.
Yes, but I will take you to what you might call the highlights, I hope.
Yes.
My lords, can I just... I've dealt with, as well, our fundamental position, I say, misrepresentation, reliance, and loss. Can I just say what the structure of my submissions will be? First, I just want to give you a very brief overview of the events in question.
Well, I think you can be fairly brief. Yes.
Oh, that would only be about a couple of minutes, Mike.
Right.
Just
Good.
to,
Yeah.
and then I just will identify the passage in the judge's judgment where we say he got it wrong, and which effectively the Court of Appeal upheld, and we say the judge got it wrong, essentially because he said there was no positive representation which was distorted by the failure to mention the lending limit. I say that was wrong. I want to do this. I want to explain why the case we're maintaining now is not different from the case that was being pursued at first instance. This is a repeated refrain in my own friend's written cases, that somehow we're sort of conjuring up, I think, to use one of his phrases, some sort of new case, which is really totally different from what was presented below. We're not. And au contraire, I submit, it is very much, the case we're presenting now was, in fact, the case which at all times until written closing submissions was the case. It's fair to say in our written closing submissions we ran other cases, but we didn't abandon this case either. So, my lord, I do want to show you that briefly, because it's a point taken against me. And then I'll go to the points we make in our case about whether there was a lending limit, the significance of it, and why it rendered the misrepresentation false, and reliance, and so on. My lords, the relevant part of the judge's judgment at first instance is in Bundle 1, at page 440. And it's first of all paragraph 67, which if I can just take you to that first, page 440. The court can find no evidence to support the contention of the defendants of misleading conduct by Mr. Ramdeen. The lending limit of the claimant, if there was one, as the evidence in this regard is unclear, was of no relevance to the loan granted to the defendants. The lending limit would only have become relevant should the claimant have agreed to finance the project or represented that it would have done so. Put another way, in the court's view, the fact that the claimant saw no need to discuss a lending limit with the defendants may well be evidence from which the inference can be drawn that it was never represented by the claimant that it would finance the project. Now there, in my submission, what the judge is saying is, well, as there was no promise by GAM that it would finance the project, it follows that the lending limit was irrelevant. I submit there's a plain error of law. It was relevant if there were discussions which made it plain, as I submit there plainly were, that the Deslauriers would want to come or might want to come back for further financing in addition to the loan that was granted. It was relevant on either hypothesis. So to say it was relevant only in the event of a promise, I submit is plainly wrong.
Well, it turns out it depends a little how they put, if at all, the proposition that they wanted to come back for further finance. If that is really an important point, wouldn't one expect parties to raise it expressly, say, look, we may need further finance and we want your assurance that you will consider it seriously. You can't undertake now, but nonetheless we want your assurance that this would be something that would be seriously considered. That you'll have to...
Well, I'll deal with that, my lords. I submit you don't have to go that far. You just have to make it plain that that's something that you will be looking for or may need in future. At that point, if
you go to a bank and you say, or if you go to a lending institution and say, I want to borrow 20 million, I might actually want to come back and ask for more. You say at that point the bank has got to disclose all its lending policies, and if it has a lending policy which make it difficult.
No, I don't go that far. I say very much depends on what the facts are. But if you say, I've got this building project, I'd like $20 million now, I might need some more finance later. It so happens that 20 million is jolly close to the bank's limit, let's say. Let's also say, as I submit the plainly was in this case, let's also say that you have a discussion about the difference between this institution and banks. And they say, well, there are no differences apart from interest rates or something. Well, at that point, the failure to say, and I should also let you know that another rather important point is, I won't be able to lend you any further finance if that's what you're thinking about. I submit, of course, the bank or the lender has to say that.
One argument against you is that this institution wasn't any different from any bank, that the only limit you can point to is one which applies to all banks.
As a matter of law, that is right, but as a matter because they were subject to a 25% limit in relation to their capital base. I accept that, but as a matter of fact, and that's why I say in practice, it was wrong, because the bank, they were not in a position, the same position as our representation is large banks, but they were not in the same position as a bank would be to keep on lending further finance, at least a sum a little bit more than what was already in issue. My lords, it was not suggested below that banks would have had any difficulty in lending more money. There was no evidence to that effect. And there's no reason to suppose that the banks would have had difficulty lending more money because of any regulatory limits or because of any
So the inhibition is not the 25%, the inhibition is what suggested is some other, internal rule?
Exactly, yes.
That prevented them getting, anywhere near the 25%, or very near to it anyway.
Yes, exactly. I'll be coming to the email where they say in terms, we would have been happy to lend you the 6 million were it not for. I'll come to that. It's a very important point.
Well, do you say that GAM was under an obligation to make that clear, irrespective of whether the appellants had indicated that they would require further finance, or might require further finance?
Well, I say in the circumstances, yes, but they did say, but the emails I'll come to show beyond any sensible question, they said, I might want further financing. And indeed, I would like financing up to 75% of the project. So that's why I say it's important.
Doesn't it depend on how somebody says that? If you say, I might want further financing, a bank manager might say, well, I'm not concerned with that now. There's no indication they won't be able to get it anywhere else if I refuse it. The market is at that stage strong, CLICO hasn't collapsed, and so on. Whereas if they actually say, look, we'd just like to discuss the possible future with you, there will be completion costs. We may have a funding difficulty at some point. We do want your assurance that you will consider it seriously. One might treat that more easily as giving rise to a legal responsibility. But the first, I might want further financing. Would someone attach legal liability to that?
Well, if someone has said, yeah, my lord, I have to come to my submissions in due course, but if the proposed lender says there are no I'm just like a bank, say for one or two immaterial differences, it might, that undoubtedly suggests there are no limitations on the lending which would prevent this lender from lending more than what's already in discussion. I'll come to that if I may.
We'll have to look at them just like a bank. The actual position is that what they were concerned to stress is that they weren't just like a bank, because they had a rather curious rule about repayment. So you had to keep loans outstanding for a year, as I understand it, from the last drawdown.
Yes,
which is very odd. Yes.
Well, that
anyway, there we are. Right, we must let you get on.
Yeah. But my lord, the other, just staying in bundle 1, page 441, paragraph 69 is the other passage where we say the judge, with respect, went wrong. Therefore, the non-disclosure of the lending limit in this case did not amount to misconduct by Mr. Ramdeen, although a fiduciary relationship may have existed between the parties. Mr. Ramdeen's non-disclosure did not distort a positive representation, the court having found there was no representation to finance the project. So it's the same logic, no promise or representation to finance the whole thing. Therefore, any representations about lending limits or implied representations about lending limits are irrelevant.
Well, you say, do you, in fact, it's the same mistake in both 67 and 69?
Yes.
Yes.
Yeah, it's the same error. My lords, the Court of Appeal appears to uphold that reasoning. If I can just give you the references. Volume 2, page 755 at para 38, and 758, para 41. My lords, I'm happy to take you to them, but essentially they appear to uphold the approach of the judge on that. And we say they've just made the same error, therefore. My lords, can I just very brief overview of what happened? And I'll then come to the details of my submissions in a moment. First, there were discussions for a loan in about June 2007, and initially GAM proposed a $15 million loan, and that's in an email of the 21st of June 2007. Now, Mrs. Deslauriers writes back on the 24th of June saying, I would like 16.35 million. But she notes that the securities that she would like to offer won't necessarily come to that. I'm speaking in summary terms. In reply, GAM on the 25th of June says, well, look, if you want 16.35 million, we are going to have 4 securities, and that would be the 2 Chamfleurs properties, one of which is Hebron Heights, and 2 properties at Goodwood Park. So they basically say, I want 4 securities in that case. To which Mrs. Deslauriers comes back on the 26th of June saying, well, in that case, I don't want you to have 4 securities. I'll just take $15 million, a loan of $15 million, on 2 securities, or rather 3 securities. That is to say, 2 Goodwood Park properties and 1 Chamfleur property, in fact, the Hebron Heights property. So that's how things are left in June 2007, so that in July 2007, what she applies for is a $15 million loan. But it's important to note that it's in the course of those emails in June 2007, when Mrs. Deslauriers is saying, I want 16.35 million, that there is, I submit without any shadow of a doubt, discussion about the need that she might have in due course for additional financing. Now, by September 2007, things change again, and so the proposal becomes that there should be 2 Chamfleurs properties, which stand as security. Their value, combined value, by now amounts to $24.8 million. And so the loan that is offered and accepted is $18.6 million. And in the course of those emails, Mr. Ramdeen says in terms, of course, if you need additional financing, and I submit quite plainly additional to $18.6 million, we'll have to run that for another year. But the important point is additional financing is mentioned both in the June correspondence and in the September correspondence. The loans are then entered into on the 20th of September. My Lords, it's important to note just a detail, which I submit this is another important point. The first is for $17,827,000 odd. These are TT dollars, I should say. That is to pay off the Republic Bank loan, which the Deslauriers already have with Republic Bank. The second loan, which is split up into a second promissory note and so forth, is for $772,581. And that is essentially to go into a building, looks like into a building account, and this is the evidence of all the parties, to enable payments to be made to contractors and things. So the point I make is that it was obvious from the very beginning that this was only a very small part of the money being advanced was actually to go towards the construction of the project, or further construction. Now, in March 2008, I'm not going to come back to this, but just so you know what is going on, in March 2008, or there and thereabouts, one of the Chamfleur's properties was released. And that was a property which had been valued at $7.8 million back in September 2007.
Value at
Had been valued at $7.8 million back in September 2007. And that meant there was just one property left as security, which was Hebron Heights. But by now, the value of that had gone up sufficiently to justify such release on a 75% loan-to-value basis. In July 2008, Mr. Deslauriers made a request to GAM in which she asked them, would you like to finance the rest of the project? An open request. And she suggests that she would like to have, if they are prepared to give her that, 75% of the current value, which is in fact quite a bit more than the 18.6 million already in issue. By November 2008, the Deslauriers are in discussions with a bank, the RBBT, and thinking of moving all their business there, as they say to GAM. However, by December 2008, they decide to revert to GAM because RBBT are being a bit slow about things. Mrs. Deslauriers said in evidence, but this was not accepted, that there were conversations around November and December 2008 in which Mr. Ramdeen said that he would like to keep her business and to offer further finance. The judge rejected that. But we say nothing turns on that point. The important point is that in that period, from July to November 2008, there's still no mention by CAM that we can't lend you any more money anyway, or certainly not much more. At the end of December 2008, or thereabouts, the Deslauriers asked GAM for a further $6 million. But GAM then says no. I would like to take you to this email, because it's an important point. On the 8th of January 2009, and there's an email you see at Bundle 1, page 236. Now, Mrs. Deslauriers had asked, I think even in late December 2008, for an extra $6 million. But you can see, if you look at 236, the second email is an email from Mrs. Deslauriers of the 8th of January 2009. And she's talking about various other things and how she might try to get some money. But then at the top of 237, you'll see the $6 million I discussed with you is not being paid back by the profit. That is the construction cost, so the profit of 27 million is an addition. If we got that from you, because of your financing, then there'd be $6 million additional in income at the end, making it 33 million, as we'd not have been able to pay you off until you say. What Mrs. Deslauriers had been proposing at this point is that if GAM lent the money, then they would, as we're in return, that they would, the Deslauriers would be putting, as it were, the resulting profits from the development with GAM at the end of the day.
Is it that, or is it that the security would go up because it would go into Heaven Heights?
Well, it would it would go into Heveron Heights, certainly. But I think, my lords, there are previous discussions where what she's suggesting is, if you help us out, we will be placing the resulting net profit we get out of Heveron Heights with you, GAM, for you to invest on our behalf.
Where does it say that?
Well, it doesn't say that here, my lord. I'm just trying to summarise what had happened beforehand. But, my lord, the important point is the 6 million. She's talking about 6 million, and there had been discussions about 6 million earlier. And then you have the reply. Which makes it plain what the request was for. Now, Mr. Ramdeen says here, I've already submitted a paper for an extra 1 million, because another 1 million had already been asked for to pay for some emergency expenses, with the condition of the sale of the land and the 10% deposit paid to GAM to be held in the money market fund.
Sorry, what are we on?
Sorry, so the top of 236. Forgive me, my lord.
236, yeah. Right, yes, I've seen that, yeah.
So Mr. Ramdeen says, well, I've already put in a request for the extra $1 million you asked for. And he explains in the first paragraph what's happened on that. And then in the second paragraph, he says at 236, I agree that your track record has been excellent to date, but we need to follow the guidelines set by our regulator. For failure to do so would run the risk of our license being revoked. If our balance sheet was much larger, then an additional TT $6 million would not be an issue. Now, my lord, I submit that in one sense, I don't need much more than that. He is saying in terms, for whatever reason, whatever precise reason, I can't give you an extra $6 million because our balance sheet isn't big enough.
Well, that's a judgment you would make from time to time, isn't it? Depending on your, does it mean that it would always have been so?
I agree, my lords, theoretically. It could have been entirely different back in 2007, 2008, in theory. But in practice, I say no. Not least, my lords, because at no point in this case did GAM ever tell anyone in evidence, in disclosure, in the pleadings, what in fact its lending limit was, if it wasn't something along these lines.
It's a slightly Delphic statement. If there had been no exchange between the appellant and GAM on this topic previously, isn't it?
Well, my lords, my position is there had been communication.
Yes, of course.
Exactly. But my lords, he's simply saying there, this is the position. Our balance sheet isn't big enough to enable us to give you an extra $6 million. Now, I submit the inference, that the natural inference one draws from that is, that was probably the position in 2007 as well. There's no suggestion things had changed. My lords, if there'd been some evidence to that effect, fine. But there wasn't. So I submit the natural inference is, that was, something along those lines, was always going to be a problem for GAM. If GAM had given evidence to the contrary, fine, but they didn't. And it was for them to explain. They knew this, we didn't. And they just chose to give no evidence on it. Well, but you're familiar with the general proposition. If I know something perfectly well and I say nothing about it, there are adverse inferences that may be drawn, if I can and I don't. So, my lord, that is, we say, the position as things stand.
Just going back, it may not be important, the top of 237.
Yes.
Do I understand the logic? I don't know. The 6 million is not being paid back by the profit. That is in the construction costs. In other words, the 6 million is to cover construction costs.
Yes.
Right? So the profit of 27 million is addition, fine. If we got that from you, that's the 6 million, there would be 6 million additional in income at the end. Why would there be 6 million additional if it's part of the construction costs?
My lord, I'm not entirely sure. My lords, can I just say this? For the moment, my case doesn't depend upon an accurate construction of that email. I'm not entirely sure. My lords, I don't want to... But can I come back to that later, if I can think of what exactly the answer is? But I submit it doesn't matter. The point is, we want an extra 6 million, to which the answer is, I'm afraid, can't do it.
Okay, and you say that throws light back on the probable factual position. We got that?
Yes. Now, my lords, after this, I'm just briefly on the introduction, there is essentially the parties discuss the possibility of some possibility of financing between January and April 2009. And also the Deslauriers tried to go off and get financing elsewhere. One can see that from their emails. However, on the 3rd of April 2009, you can see, if you go to Bundle 1, page 167, GAM says, in an email to Mrs. Deslauriers, 167, second email of the page, I have today received a response from our committee. The committee indicated it is unable to entertain the request for additional funding at this time. They noted that the maturity date of the facility is April 2nd, 2009. I accept that. Prepared to grant an extension to allow you the opportunity to seek refinancing. So it's at that point, as it were, a firm no comes back.
Yeah. Now, there's no reason in that. Is the only one that provides a reason, the one that you took us to earlier on 236?
Yes, I mean, it's not suggested there was any other reason, no. Not in evidence from the pleadings.
Well, have they disclosed? Did they disclose the bank their internal committee minutes?
No. And that's the point I'll come to. Sorry?
Did you ever ask them?
Well, it wasn't an issue on the pleadings. I'll be coming to that. I don't think we did, my lords. I can't say we did ask, but the fact, I'll come to the pleadings in a moment, because GAM didn't plead anything to contradict our case, apart from bare traverses.
By April, the market's collapsed, hasn't it?
Yes, by then the market had collapsed. Well, it was by the pleading time, it was sort of late 2009, early 2010, so whether the market was coming back up a bit.
Well, I'm sorry, yes, but is it right that by April the climate was rather different?
April 2009, the climate was very different.
Thank you.
Yes, because of the CLICO, what is called the CLICO.
Quite.
Disaster, which took place at the end of January 2009.
Okay.
But anyway, the position is no-go is confirmed on the 3rd of April 2009, and then you'll see the first of many complaints is made by my client at the top of the page, 167. And she says, first few lines, she's in Texas. Then she says, second sentence, project is 6 months late. Nothing unusual in that. And then 4 lines down, in future, letting your customers know the GAM limitations in funding is crucial when taking on a project that's over double the lending capacity of the company. I know you must have done your best, so we'll now look to another who never abandons. I'll be in touch on my return. So there's an immediate complaint about, hey, you didn't tell me this before. She's referring, obviously treating the rejection on the 3rd of April as being referable to what was said in early January 2009. Now, my lords, I'll come to this briefly. We refer to it in our case. There's then a series of correspondence which goes on from April essentially to middle of June or thereabouts in 2009, in which my clients vociferously, I think it's fair to say, and often in capital letters, complain about the failure to mention this lending limit. There is no response by GAM to that point. They never said, well, we did tell you about that, or, well, it's totally irrelevant, or, hang on, what are you on about? We don't have this lending limit you seem to be so concerned about. In any event, no refinancing is found in 2009, and proceedings are then instituted by GAM on the 20th of November 2009. So, in other words, that's what you might call a potted history of the case from our point of view. Now, my lords, I've mentioned this, the respondents in their case said, well, just, it's not very surprising the judge didn't deal with our arguments below, or indeed, not very surprising, there was no cross-examination on questions of reliance or misrepresentation and so on. Because the case we now pursue is really quite different from the one we pursued in the first instance, and there are a number of references I can give you to the respondent's case, but that's the thrust of it. My lords, I submit that is wrong. If I can just briefly take you to 1 or 2 points in the pleadings, then the evidence, and then what happened at trial, I hope to make good that the case I'm now running is not a new case or some sort of variation, but the case, or one of the cases, that was always put. And the first document I'd like to go to is the pleadings, and Bundle 1, our defence and counterclaim, at page 42. And one can pick it up in paragraphs 10 and 11. The claimants always knew that the defendants were accustomed to dealing in Trinidad only with banking institutions. And then 11, at all material times, it was in the claimant's knowledge, or the defendants expressly made known to the claimant, they didn't have any knowledge of the workings and operations of the claimant, and any limitations on the claimant's lending powers, and relied upon the claimant to indicate the same. And then para 16.
Well, you say expressly made known that your clients relied on GAM to indicate its lending limits. That you can't sustain that, can you?
Well, I'm just for the moment just saying what our allegations were,
right,
rather than whether they were right or wrong.
Yes.
If I just what was our case?
Right.
Paragraph 16. In the final meeting, the claimant's representatives orally represented the defendants. Following inquiry, it had been informed how the claimant's policies differed from large banks, as well as any other pertinent information, that the only difference between the large banks and the claimant was that loans from the claimant could not be repaid before 1 year from receipt of fund. And then 17, based on the claimant's inquiries of the whole project, the documentation they'd requested, relying upon the representations made by the claimant's representative, as the defendants were induced to give the claimant the business of financing its Hebron Heights project. And then para 20 is an averment as to how GAM ought to have understood, or ought to have realised the claimants would take its statements. Defendants would aver, the claimant knew, ought to have known, the defendants would have taken the statement, that the only difference between the claimant and large banks is in terms of the time for repayment, to mean the claimant was as capable as a large bank to provide financing for construction of this size to completion. So that, my lords, is what you might call, you led us to believe you were capable of financing it. Now, my lords, paragraphs 21 to 23 then go on to deal with the other allegation, namely what you might call the allegation that you would finance it. You said you would finance it. And you see that in paragraphs 21 to 23. And basically what's said is there is, well, you asked us, paragraph 21, you indicated orally that you desired to keep our business. That's paragraph 21. And then we say we accede to that request. And then in the premises, we get paragraph 23, which, as it refers to, and I have to accept this, refers to a sort of a promise which suddenly emerges without actually having been particularly identified in the earlier part of the pleading.
It seems to be an invitation to deduce that from everything that has been said hitherto, including all the bits that you gave us just now.
Well, my lords, possibly. my lords, I submit not, because there are plainly independent allegations in any event. And then, my lords, paragraph 31, you'll see the plea that we're relieved of the obligation to repay the loan. And then you have the counterclaim.
You accept, presumably, do you now, or perhaps you don't, that as far as the promissory notes are concerned, it's quite difficult to see that you have any answer, but there might be some ground for a stay.
Well, if you were to find that I'm entitled to damages to be assessed, then, my lords, I would be suggesting that it would be just to order a stay, but there are, of course, the other arguments.
Would you accept that on the face of it? I mean, it's a minor point, probably,
well,
yes. We're all seen that the promissory notes must be paid out
yes,
willy-nilly.
Yes,
and even a stay is, we might have to look at that, but even a stay is a relatively exceptional remedy.
You would certainly, on a promissory note, give a judgment. I accept that.
Yes,
the only question might be whether there should be a stay of the judgment.
Yes.
Right. But, my lords, then dealing with the counterclaim, just going back to the counterclaim, or rather at this point that we ran this case below, paragraph 34 is a specific plea that there was the defendant was under a duty to disclose the lending limitation. And then 35, again another specific plea.
It's a duty of care. It's a plea of an action in tort, isn't it?
Well, it is, my lords, but I respectfully submit it is also pleaded as a misrepresentation.
I follow.
My Lord, I submit that whether the word misstatement is used or not, I submit that bearing in mind the positive representation has been alleged, then it's fair to say, well, you came under an obligation, because it was misleading, to tell me this, and you didn't. But the real point is, this is an independent allegation being made here. You failed to tell me about your lending capacity when you should have done, and that's 34 and 35. And 36, all of this.
Picking up my Lord's point, the duty of care is something that can be alleged at any time in history.
Yes.
The misrepresentation point, is that true of that? Does it depend upon the act and upon the misrepresentation inducing a contract? Or?
Well, yes, it does. But in my submission...
So it's something which has to be related to...
Yes, absolutely. My Lord, what I said, there was here a representation about the only differences. That was not correct, because there was another difference which should have been mentioned. Had it been mentioned, good, but it wasn't mentioned. Therefore, there was a negligent misstatement or misrepresentation about capacity. But, my Lords, I accept here the words misrepresentation are not being used in 34 and 35, but they are tied back, of course, to previous representations specifically alleged, which are said to have induced us to enter into the contract.
But you haven't pleaded here, have you, that there was a breach of a representation but for which you wouldn't have entered into the contract. What you have pleaded is there was a breach of a duty, but for which you would have done something before December 2008. But I don't read this as saying that you wouldn't have made the contract, which is now, I think, your current case.
Well, my Lords, I think one has to go to 36 as well.
Well, you have repeated 1 to 31, I suppose.
Yes.
Yes,
We
so
certainly repeated 1 to 31, yes.
So one's got it from that, hasn't it?
And then look at the particulars of 36.
Yes. Right.
My Lords, I submit, well, it may be that one would have pleaded it slightly differently, but the facts alleged in this claim are clear enough. Namely, you said one thing to me, that was not true, you therefore came under a duty to tell me the truth.
So it's paragraph 17, which is really the critical one, yes. They were induced to give the business of financing.
Yes. And 34 to 36 in my submission are on any footing allegations which go back to the failure to mention the lending limits. This is the counterclaim. And then, my Lords, you get a rather sort of lonely paragraph 37. You get the breach of agreement point.
Yep.
And then you get 38, the loss point, which is pleaded in a sort of what you might call conglomerate way. It's not split up between either one allegation or the other. But, my Lords, I just emphasise, and my Lords, also in the prayer you'll see misrepresentation is alleged, just in case anyone was in doubt. As well as negligence. So, my Lords, that's why I say this case, which I'm now pursuing, was properly open on the pleadings. My Lords, just dealing with the witness evidence, there was only one witness on each side. Mrs. Deslauriers' witness statement. If I can take you to page 196. The paragraph 197. Paragraph 11. I think Mrs. Deslauriers is putting this around June, or at least certainly before the contract. Mr. Sancerre called again, pursuing the business. We agreed to meet with them once more on a serious note. At this meeting, we told them that we were unaware how they differed to big banks, having never dealt with non-bank before, either in the US or here in the development projects. We were told confidently by Mr. Sancerre there was only one other difference, and that was that the loan couldn't be paid off until 12 months passed. At this time, Republic Bank charged higher interest rates and so on. And then she goes on in paragraph 12 to say they discussed how the construction would be funded. And then paragraph 13, just for the moment on how the case was put. Paragraph 13 Based on the understanding, the claimant's representative indicated the only difference was that the claimant and the bank is that payoff couldn't be done before 1 year. He didn't indicate any limitation on the lending capacity, and we were returning for funding. At completion, we agreed to move our business from Republic Bank. And then, likewise, you have paragraph 16, by letter of the 14th September, the claimant advisors bridging financing was approved. We had one final meeting on the 20th of September that day, and again clarified that the only difference between them and the big banks was the 1-year criteria, and the loan couldn't be repaid in less than at that time. Took out the facility for 18 months. And then para 17.
Just tell me why, as a matter of interest, why would your clients be returning for funding only at the completion of the construction phase? One would have thought that that's the last point when they would need for funding because they could sell.
No, well, no, we've got the finishes. The construction phase is used in contrast to the word finishes. In other words, you do the outside bit, and then you've got to do the internal decorations, put the oven in, and things like that. That's the difference. And paragraph 17, you'll see Mrs. Deslauriers refers to a short conversation she had at this time, the final paragraph. She again repeats the point that she relied on the representation, there were no differences. At the final paragraph, final sentence of para 17, again, based on what was represented, concerning the difference between GAM and ordinary banks, we didn't see any reason to not continue with the claimant.
And where in the pleading and in this witness statement is there evidence of other institutions which would be prepared to fund?
My Lord, I think, while I'm on it, I think para 22, I've got the references somewhere else. Paragraph 22, paragraphs 21 and 22, she deals with her conversations with RBBT. This is later on, in November 2008, or thereabouts. And in this passage, 23, 24, 25, well, 23, up to 23, she's saying,
when you say RBTT offered to continue to finance the project, what were they approached for? Indefinite funding or some specific sum?
I don't know.
Have we got the documents?
No, we don't.
Why were they not disclosed?
I can't answer that, my Lord.
Yeah. Well, how do we know what they were being asked for? They may have been asked for a substitute loan of a definite sum, or
well, you have her word that they were they were prepared to offer more, or at least, my Lord, one thing, that they were prepared to offer at least what GAM had offered, and that they would not have been subject to the same restrictions. That much is clear.
Where do we get that they were willing to offer any figure?
Well, 22, when I met RBT.
Interested in the project, yes, clearly.
But if your case is based on this is an important area. This is the obvious alternative source.
Yes. Well, I agree.
There's a slightly oblique reference to it in 23. In mid-December, we declined RBTT's offer to continue to finance the project. But nothing more specific than that.
No. I don't think, my Lord, I'll just check my notes, I was going to come to this later. I don't think there's anything else in Mrs. Deslauriers' evidence about what the deal from RBBT would have been. She is saying, however, I was in discussion with RBBT and I would have been able to stay there. Now, we know that there's no suggestion RBBT would have had the same restrictions.
RBBT isn't their, sorry, RBTT isn't their original bank, is it? It's a different one.
That's a different one, yes. My Lord, for the moment, I'm just on the question of what was the shape of the case, rather than reliance and loss and things. my lords, at paragraph 28, I'm just looking at what the shape of the case was below. Paragraph 28, page 203, she refers to the correspondence which she wrote, I'll take you to this later, about their inability to complete the project. And paragraph 30, she again complains, or she refers to correspondence where she complains about their misrepresentation of their ability to fund the project. Now, my lords, I submit, when you look at the pleadings and the written evidence, there's no doubt that the case I'm presenting is in line with the way it was presented, or as would have appeared to anyone at the beginning of the trial. Now, there were no written openings at the trial, before the trial, and there were short oral openings, and you can see that at page 334 in the first bundle.
Sorry, page?
334.
Thank you.
And you can see that Miss Peake, page 334, about three-quarters of the way down the page, Miss Peake opens, or rather, very near the end, Miss Peake opens case for the claimant, and the break is then taken at 11:47. It would seem she must have opened for, if you go back to 332, you can see the court had resumed at 10 o'clock, and there are a couple of pages between 10 o'clock and Miss Peake's opening. So presumably it's quite a long opening. About an hour or so, maybe. And then if you go to 389, after Mr. Ramdean's been cross-examined, Mrs. Deslauriers gives her opening, which you can see at 389, the foot of the page. Matters called back at 10:17, and the case for the defence is put. And it would seem that she takes about 50 minutes or so, because you can see that after a few questions, the cross-examination of her begins at 11:15. Now, my lords, I've asked, can anyone remember what exactly Mr. Deslauriers said? Because the answer is no. But I say, whatever the position is, and this is important, I say whatever the position is, there is no excuse that, so far as my learned friend now says there is one, for not cross-examining Mr. Deslauriers about absolutely fundamental parts of her case. In particular, on what was the misrepresentation, or what was the relevant representation, and questions of reliance. You say you moved your business on the basis of this, but there was none. Absolutely none. And I submit that was a fundamental point in the case, and it cannot be got round by saying, oh, well, we're now running a different case. My lords, there were no oral closings. You can pick that up from page 414. Sorry, it's the end of the judgment rather than the beginning of the judgment. You can pick that up.
412.
412, yes. Sorry, forgive me, 414, right at the end of 414. I was right the first time, forgive me. Right at the foot of the page, after the evidence has been given, the judge then orders submissions sequentially, with my clients to give...
You say there's no cross-examination on fundamental parts of the case, but I think you'll have to make that good, because I mean, these are notes of cross-examination, but it's quite apparent that counsel's line, having read the cross-examination, was, look, your case is completely inconsistent with the documentation. There's nothing that could be a representation. That at least is clear. Would you accept that so 398, would you accept that nowhere in the documentation you looked at is there any reference to your coming back to GAM for funding after the completion of the construction phase? Can you point to any document that reflects when you were discussing loan with GAM which said you would not be back for funding until the completion of the construction phase, etc., etc.? Now,
Right, a purist might say you should put and it's not true, but it's quite obvious that what she was saying is, look, it's not true because it's simply inconsistent with the documents.
Well, my Lord, I'm not saying there was no cross-examination, but there was certainly no cross-examination on the question of reliance, and no cross-examination on the question of what was the representation made about the difference with banks.
But did she give evidence, Mrs. Deslauriers, that she would have got other funding from elsewhere, that it would have been available?
She didn't go that far. She didn't. No. Well, I've taken you to the witness evidence. No, she didn't. She didn't give evidence in cross-examination about what else she would have done in reliance, because she simply wasn't cross-examined about reliance in the first place.
Witness statement. That's the
well, she had said something about it in her witness statement. She certainly said
she'd been having discussions with RBTT and had decided not to continue them, but to stick with GAM.
There's that, but also there is her evidence that because of what GAM told her, she decided to go with GAM. That is evidence of reliance.
Yes, got that.
You may say that reliance there are two sides to reliance. One is you say you did trust what you were said and you relied on that. The next question is, but for what would you have done? Now, on that I accept there's only the evidence about RBBT, the latter point. The point I just wanted to make, my lords, is that there is no excuse, but I will be coming to this later, for the suggestion that when I say Mrs. Deslauriers wasn't challenged on material parts of her case, it's not an answer to say that's because the case you're now presenting is different. It is the same. My lords, just as far as written submissions are concerned, this concerns more the judgment. Mrs. Deslauriers, you can see at page, they begin, I think I'm right in saying, at page 274, closing argument on behalf of the defendants. Now, for the purpose of this document, the appellants had the assistance of a Trinidadian lawyer called Mr. David West, but he hadn't been present at the trial. He just helps, as it were, draft, and you can see there's some legal points mentioned. But I just want to show you how we say the points which we now rely on were still in play, even in these submissions. And first of all, paragraph 23, there's a short description. This is part of a description of the events.
This page?
279. Sometime after Lear returned to GAM, only to be told the lending limit was 24 million. That was never revealed to defendants before, and if it had been, they wouldn't have pursued the additional funding, but would have gone with RBTT. In fact, if they'd been told this in the initial meetings, defendants would never have entered into the agreement. So the point's being made there in terms that this was a material representation on which she relied.
Well, in 2008, that is.
Well, my lords, perhaps also, in fact, if they'd been told in the initial meetings, that must be.
But 23 is surely about sometime after Lear returned to GAM, is all about 2008, isn't it?
Yeah,
well,
I think that's, that sentence, in fact, they wouldn't have entered into any agreement, and the promissory notes must be 2007.
Yeah, forgive me.
Yeah.
Yes, yes. So
She's not here talking about the original agreement on the promissory notes. She's talking about the 6 million extra being sought in 2008.
Yes, but she's then referring back to the point. I accept that. But then she's referring back to, or she's referring back to, in fact, if you told me this, I wouldn't have gone into the contract in the first place.
This is the bit you want. In fact, if they'd been told this in the initial meetings,
the defendant would never have entered into any agreement with GAM, the promissoriness wouldn't exist, and so forth. So that is the point. The point's in play on any footing. And then paragraph 32, page 281, I think. Now, my lord, one of the arguments running closing, which you see referred to in the judgment, is that there was some sort of, quote, professional negligence on Mr. Ramdean's part, because he didn't realise that the the Deslauriers would have wanted further financing. I'm not pursuing that allegation. It's a sort of development, if you like, of the original allegation. But the point being made is still here, para 32, they're still here where they're saying, you didn't properly understand the nature of the loan or what we were asking for. And then 42 to 43, at page 284, They're alleging, this is again in the what you might call professional negligence claim, they're alleging that if it was obvious from the June 2007 emails, which I'll come to, that what the defendants wanted was a long-term relationship and that we would require additional financing. The point's being made again there. In other words, that the email chain makes it plain, especially 43, that we would want further financing. So, my lords, I accept it's being put on a slightly different basis, namely professional negligence, but this is a litigant in person after all. It's obvious, and one would expect a reply from leading counsel to what you might call cover the point in relation to the main claim, which was pleaded.
Well, 34 to 43 are under the heading professional negligence.
Yes.
And negligent misrepresentation comes next at 45, is that right?
Yes, that's right. And then 51, under that rubric, you get paragraph 51 on page 287. Basically saying, well, Mr. Ramdeen would have known of the extra finance that was required. And then 52, the allegation that, again, the allegation we moved because of the statements made by Mr. Ramdeen Sancerre. And 53. Again, my lords, I submit that these are certainly within the main case, which I call the main case, about you didn't tell us about your limits. 52 in particular. And then page 290, paragraph 67, 1. It's in the context of 64. Can silence constitute a misrepresentation? And the answer is yes. And then subparagraph 2 is what you might call the promise point. And then the conclusion is in 91 and 92. Now, my lords, I accept there are differences in certain respects. The thrust of this findings is certainly not to abandon the case that was made that you misled us about your lending capacity. Now, what's interesting, I very briefly I can deal with this, GAM don't bother to deal with it. They just ignore this point. So if you look at their case, which begins at record 1, page 306, sorry, it begins at 301. After a short introduction, page 306, paragraph 24, they refer to the allegation about non-mention, the failure to mention the lending limits, paragraphs 24 and 25. They then go on at page 307 to put, so to speak, as their advance point, the promissory note point. And 35, they say, because of the promissory note, that the allegation of negligence doesn't help the defendants, Deslauriers. They then go on in paragraph 43 onwards to say there was no evidence of an alleged promise of further financing, and that continues all the way to paragraph 60, that rubric. And after that, they deal with certain written submissions. They just deal with individual paragraphs in our written submissions. But they don't, as far as I can see, deal with the paragraphs I've mentioned, or the particular point, namely, you misled us on the lending capacity, because there were these limits. My lord, so if I may respectfully say, the problem is not so much my clients who are altering their case, is because the claimants have just ignored it, and the judge has run with it. So, but in any event, my lords, what I say is this. We can't, it's not an excuse.
I mean, aren't they saying, I'm just taking the answer, paragraph 91, the conclusion, 295 of the Deslauriers case,
yes.
where paragraph 91 they say, had GAM properly represented their position, that this was to be a short loan and they never intended to see this project to completion, the Deslauriers, who stated many times they were seeking a long-term relationship, would never have agreed to do business with GAM. Right. Well, the answer to that is at page 328.
Yes.
As to paragraph 91, there's no evidence led at trial to establish that the claimant did anything other than to agree to grant an 18.6 million loan to the defendants. The evidence establishes claimant's representative would grant the defendant such a loan, and the claimant did so. So, I mean, basically, they're saying this is all a chimera, and there's nothing in your representation case or in any case based on anything except a loan agreement for a limited sum.
Well, they may be saying that, but what they are dealing with, what they do is they deal with the case put on the basis of a promise. I agree with that. And they say, well, that's all nonsense. One of the points they make, which is correct, was not actually my client's evidence that a specific promise was ever made. I mean, the promise case is always a dead duck. I mean, that is the problem. And, my lords, what one's got in this, if I may be blunt, my lords, one often knows that litigants...
One's diverted by dead ducks.
Well, I know. But, my lords, here there's a litigant, but this is the problem we all know about. But a litigant in person often does run what they think is sort of a great case. It was actually not really a case which is supported even by their own evidence. And they ignore, or they don't ignore, but they put to second rank the case which their evidence does support. Now, what's happened here is the case which was, let's say, elevated to the main case has been dealt with, and you can forget about the case which was in the second rank. Now, my lords, I submit at the best, even when there are represented parties, you can't just pretend someone's dropped their second case, but this was an unrepresented party. And I do respectfully submit fairness, at the very least required both leading counsel and the judge, and say, well, look, you may, he's put a case on that basis, here are my answers to that, but as to the other parts of the case which have been pursued, this is what we say. Rather than sort of make out it's all been dropped. Or suggest, I'm not suggesting any wrongdoing by leading counsel, I hasten to add, but on the other hand, it was open to answer, and I submit it should have been answered, what you might call the case which we were putting second, because it was still there.
Well, I think paragraphs 90 and 91 of the GAM do actually respond to 91 and 92.
Well, my lords, I accept that, because 90 and 91 you can read as simply being the promise case. I accept that. But, my lord, the other points...
Well, they say the claimant was under... the evidence doesn't establish any obligation to give notice to the defendants that the claimant had no intention of seeing the project to completion. That covers the representation case, doesn't it, as well as the promise case?
No, in my submission it doesn't. It does not cover the you misled me about your capacity. It doesn't. No, not at all, my lords. I submit there is a difference between you promised to see me through and you said you led me to believe you could see me through.
I know the difficulty is that your conclusion didn't focus on capacity, did it? What it focused on was intention to see the project through to completion, and that's squarely denied.
Yes, well, I accept that, my lords. But, my lord, you have my submission. It doesn't follow that the other case is being abandoned, because it most certainly wasn't being abandoned. But, my lords, you have my submission. I submit the case I'm now running was before the court at trial. The most that can be said is, well, the final submissions created a diversion. But they certainly didn't abandon the case, which was on the pleadings and in the evidence. That's how I put it. Now, my lords, can I deal with our, as it were, the first point which I want to deal with is the question of, well, were there any lending limits at all, or relevant lending limits at all? Because, of course, if there weren't, there's no misrepresentation. Now, my lord, what is said by GAM in paragraph 72, I think, of that case is, well, effectively, it's for the Deslauriers to prove that there was a limit, and we failed to do so. Now, my lord, I submit that's one only has to sort of state that proposition to see what an unattractive proposition it is. Here is a person who was in full possession of all the relevant facts, who has chosen, and I submit it has to be chosen, not to say a thing about them after that, after the correspondence.
Which page is paragraph 72 on, please?
I think 900.
Yes, I see.
We fail to discharge the burden on us. That's why I say, well, when you, I submit that comes out at one. And it really does highlight the importance of a person who is in possession of the relevant knowledge saying it, because that's obviously an unjust thing to do for a person who knows all about it but decides to say nothing about it.
Well, your beef has been, your client's beef has been from, as you pointed out, sometime in January 2009 onwards,
Yes.
that they weren't told.
Yes.
About whatever these lending limits might be. And although she was in person, what was put to Mr. Ramdeen, if anything? Presumably he was asked about it.
Well, he was. I'll come to that in due course. But my lords, the real point is that it's been suggested somehow it's for me to prove this. Well, in one sense, that may be true as a matter of what you might call strict legal logic. But on the other hand, one way of proving things is by saying, well, the person who knows all about this has chosen to say nothing about it whatsoever, in circumstances when you might have expected him to do.
So their silence is the evidence, effectively.
Well, not only evidence, but pretty compelling, added to the other things, yes.
Well, coupled with Mr. Ram's
Coupled with.
email, where he
Yeah.
says,
Yeah.
if our balance sheet was bigger, we'd be happy to lend you more, which suggests that there was some sort of limit arising out of the size of their balance sheet.
Yes. It suggests that. And also another point I would like to make, there's no suggestion whatsoever there was anything wrong with this project. And this was a perfectly financeable, no one has suggested this was not a financeable project. So, my lords, I've taken you to the email, which you have paragraph, page 236. You don't need to see it again. The only thing I would like to mention is a point we make in our case is this was obviously a considered response because a few days earlier, Mr. Ramdeen had said in answer to the request for $6 million, I'll have to go and ask my, I think, a credit committee or lending committee, and I'll get back to you. So this is not just as what you might call a one-off response. It's on page 233 of the record. You can see that this was not just off the top of his head writing it in a hurry. You can pick it up at 234. An email from Mrs. Deslauriers on the 29th of December 2008. Leon, do you need anything more from me? And do you wish to get together regarding the additional financing? And then he initially replies at the end of December, I'm discussing with the chairman of the investment committee today. Come back to you shortly. So that's the context in which he says this. Now, afterwards, on the 6th of April 2009, page 167, I think I've taken you to this, you have the confirmation on the 3rd of April that the credit committee is not prepared to entertain the application, and the immediate complaint by Mr. Deslauriers at the top of the page. Now, what in my submission is significant is that not once does GAM, throughout the correspondence which follows, contradict the assertion that it didn't reveal the lending limits and that there were lending limits. And the same point applies to the pleadings. I'll come to in a moment. So, for instance, if I can ask you to look at page 170, 169, there's a letter from Mrs. Deslauriers, which is following up from the 3rd of April email, which I've shown you. There'd been no reply to that. Follows up from 3rd of April email and makes various complaints, but in particular, you'll see at the foot of 169, you're aware that other banks were seeking our business, but not being told of your limitations, we decided to remain with GAM as a gesture of loyalty. And then she said only to find out in mid-December that GAM's total lending limit of $24 million, unable to complete the project. And then over the page, the second paragraph down, it's not the issue of your limited lending capacity that's left us feeling so betrayed, but rather this crucial detail is never mentioned over a 2-year period from when you began seeking the business. Had we been informed of this in August 2008, we had ample time to see things in place to pay off by October the 2nd and so forth. And then she goes on to complain at the foot of this paragraph, was specified, talking about 2007, was specified in our meeting in 2008, we would need additional financing. Anyway, so there it is, you have a complaint. You never told me about this. Now, GAM does reply to this letter at page 172. Now, what Mr. Ramdeen says is this. He says, well, I don't recall there being any discussions about you wanting additional financing. And you can see that in the third paragraph on 172. So he puts in issue the suggestion there have been discussions about further financing, but he doesn't put in issue the question of lending limits. Rather, you see the foot of 172. In December 2008, you advised us you had withdrawn the financing application made to RBTT for various reasons. At that point, you made your inquiries as whether we would consider additional financing for the project. We did advise that given the total of such loan would exceed the amount which we would be allowed to lend on a single project. So he appears to be accepting that there was a limit, and that's what he'd said. Can I just also ask you to note what is said at 173, the final 4 lines on 173. This is about discussions about additional financing before the contract in 2007. As regards your assertion that in 2007, during the course of a meeting with myself and our then general manager, that you indicated that you'd require additional finance funding, I've been unable to find any notation of this indication. It was not borne out by subsequent discussion or correspondence. Now, my Lord says, he's just basically said, well, I can't say anything about it. I'll be coming to the emails, which I submit show clearly that he's wrong on that. Moving on to page 250, is an email again from Mrs. Deslauriers, halfway down 250, and again she complains after a meeting she's had with Mr. Brent Ford, who is a managing director of GAM by this point. She complains about not being told about the limit. About 6 lines from the end. And the whole thrust of this email is a complaint. You didn't tell us about your limits, and I've never come across such a situation before. Now, this is putting us in a lot of difficulty. My Lords, you will see, although this is not actually in the pleadings, but you will see at this point, page halfway down 251, the total amount needed was 10 million for the finishes. And there are 1 or 2 other references to total amount being 10 million that was needed in the correspondence, but not in the evidence. But anyway, here's a complaint. Now, one looks at GAM's reply at 253. This is again from Mr. Brent Ford, with whom the meeting had been on the 3rd of June. And he denies in the second paragraph any commitment to see the project through. And then in the final paragraph, he alleges that the Deslauriers has indicated the financing must be done through this loan, and financing would come from other sources, and no discussion that further financing was needed, and so forth. Now, my Lords, what again is noticeable, he's Not saying, well, we did tell you about the lending limits, or we haven't got any lending limits. It's just, well, you never let us, you never told us you would want further financing. To which Mrs. Deslauriers replies, page 258, or rather, it's not a reply. Can I just ask you to look at page 258? Now, you'll see here, this is June 2009. By now, the Deslauriers are looking for financing elsewhere, but the financiers elsewhere want to know why it is that GAM aren't producing any more finance. That's the background. And so you'll see halfway down 258, Leon or Dave, that's Dave Dookie, here's the last request. I got the letter on the payments, not needed. I need to email them the promissory notes. That's them as an alternative financier in America, I think. They prefer email, and so on. I need a letter from you stating the following, as you can see by reading the correspondence below. And then she writes out what she wants them to say. Dear Mr. Deslauriers, we are unable to meet your request for completion financing due to the fact the amount exceeds our lending portfolio. As agreed, we've extended the payoff date to 1st July to allow you to secure alternative financing. So please let me know. Then you get a response at the top of the page, attaching the two promissory notes. You'll see attachments. Doc C is a promissory note, so is Doc B a promissory note. And then two other bits of correspondence, which had already taken place, but which don't actually take matters anywhere. Good day, Leah. Here's the information attached. But they don't provide the requested for letter. But on the other hand, they don't reply and say, look, we don't have any lending limitations. We don't know what you're talking about. So, my lords, that's the contemporary correspondence. My lords, one then looks at the pleadings. And my lords, we set all this out in our case, paragraphs 15 to 17, which is at page 840 to 842 of the electronic record. My lords, can I just put it in a few words? I'll take you to one or two examples. I respectfully submit any fair reading of the pleadings contains an implicit admission that there were lending limits, and certainly no positive averment that there were not, or indeed any averment as to what they were, if they were not of the sort we were alleging. And first, page 51. This is paragraph 4. Here's the reply and defence to counterclaim. And what GAM are doing is answering paragraph 11, which I took you to earlier, which is at page 42. The allegation that we made that you knew that any limitations on the lending powers were important and we'd rely on them. And then paragraph 4, in reply, and further answer thereto, the claimant says, in any event, it's under no obligation or duty of care to discuss the defence the issue of the limitation of its lending powers. Now, I'm not saying, well, we didn't have any. We're just implicitly accepting that. Likewise, if one looks at paragraph 20 of the defence and counterclaim at page 44, where I've shown you this before, where we allege what we took the the GAM statement to mean about capacity to lend. You look at the answer to that at page 56. Sorry, I think I've given you a wrong page number. 54, paragraph 20. No. 53, is it? Forgive me. Yes. Yes, paragraph 9. Again, nothing about what the lending limits would have been. And then I've shown you paragraphs 34 to 36 of the defence and counterclaim, or the counterclaim, page 46. Just to remind yourself, this is 34 to 36. I've shown you these before, where we allege breach and so on and so forth. You look at page 56. You just have bare traverses. But the short point is there's no positive case being put forward to the effect, well, we didn't have any lending limitations and so on. And, my lords, I submit that's important. This is not a bare pleading point, it's a real pleading point, bearing in mind the importance of the case, the issue, and the way it's been dealt with by GAM. Can I just briefly go to the bundle of authorities, and I think it's at tab 1. And this is the civil proceeding rules, which have similar provisions to those in England, page 920.
Sorry, it's Mr. Knox, this is one.
Volume 1 of the joint bundle, forgive me, page 920.
Page?
920.
Yes, thank you very much.
Rule 10.51. And 10.51, defendant must include in his defence a statement of all the facts on which he relies to dispute the claim against him. Then sub 4, perhaps more relevantly, where the defendant denies any of the allegations in the claim, form or statement of case, he must state his reasons for doing so. And if he intends to prove a different version of events from that given by the claimant, he must state his own version. Now, well, that, I submit, would plainly apply to an allegation that you were subject to limits, which you didn't tell me about. And then 10.61. The defendant may not rely on any allegation which he didn't mention in his defence, but these important words, but which he should have mentioned there, unless the court gives him permission. Now, I submit it should have been mentioned. This isn't just one of those allegations you can say, oh, well, I can understand why you didn't mention that. It was more or less within the pleadings, or to be made plain in correspondence, or something like that. This had to be made plain. They don't. And then you'll see 2 and 3 provide for cases when you can be given permission, a case management conference, or later, if there's been a significant change. Now, I don't want to just hang my hat only on pleading points, but on the other hand, these are the rules and everyone's taken to know them. And this was such an important point in the case, I submit the correct conclusion is there were lending limits which prevented GAM from lending on this particular project an amount up to of the $24 million or so requested. How much they were prevented between 18.6 and 24.6, I cannot say. But I submit you should have no hesitation saying in practice there were these restrictions. My lords, the next point is this, and it follows from the pleadings, no disclosure was given by GAM on this point. It was their obligation, if this was a relevant issue in the case on which they wanted to advance a positive case, to give disclosure. They didn't. The fifth point I make is there was not even any written evidence from GAM on the point. And indeed, what GAM did say in its written evidence, in Mr. Ramdean's witness statement, in paragraph 26, if anything, seemed to, albeit not in the same language, seemed to accept there are at least some problems with granting more finance, and that you see at page 76 of the first part of the record. Paragraph 26. He says what he told her, more or less along the lines of the email I showed you earlier. We're now in January 2009 or late December 2008, it doesn't matter. I spoke to Mrs. Deslauriers on the telephone, told her following our exchange of emails in November, GAM is expecting to receive full settlement in January 2009. I explained that if GAM were to loan an additional sum of $6 million, this would result in exposure in relation to one single client, equivalent to GAM's entire issued share capital, $25 million, and I didn't think that GAM's risk committee would approve such a transaction. So, my lords, I submit the position is clear. Now, in cross-examination, Mr. Randine did say, I turn to page 350, it was put to him by Mr. Deslauriers, page 350. I'll perhaps pick it up. The relevant passage begins at about 349, where Mr. Deslauriers begins cross-examining on paragraph 26 of the witness statement, halfway up, 349, halfway down. And some interruptions from the judge because the question isn't quite put in the way it should be. And you'll see halfway down 350, the court says to Mr. Randine, you're being asked about the 25 million ceiling, whether that applies per client, or whether that's the most you can lend per client, or is that the most you can lend in total? In other words, what is the 25 million a ceiling of? Total lending, of all GAM's lending, or just per client? And then what's your answer, the court says? He says the answer is no to either of those questions. And then there's no limit on our lending portfolio. And then I may as well, while I'm on this point, Mr. Deslauriers, I'm in shock, court. Was that your full answer? He says, yes, my lord, court. My lord, I jump a bit, but you'll see there, court, next question. It is a point I'll be coming to. This constant next question is a sort of, right, move off that topic and off you go on to another one. The point is reverted to at page 366 and a quarter.
And I think 352.
Oh, 352, I'm obliged, my lord, yes. I do forgive me, yes.
Top of the page.
Yes. And he basically makes the same point again. There's no limited lending portfolio. And then the point is reverted to at page 366 and a quarter, still in cross-examination, where he again repeats near the top of the page, we have no limitation on our lending portfolio. Then he goes on to say, well, it would depend on a lot of factors. And he's then cross-examined over the next page or so by reference to GAM's accounts for the year ended 31st December 2006. And it's put that they show, on the basis of a 25% figure, that GAM could lend no more than 32 million. But Mr. Randine, in a sense, can't adopt that because he's already said there's no limit. But anyway, that's the position. Now, that my learned friend relies upon what you see at 366 to 367, and indeed 368, for the proposition that, in fact, there was no relevant limit on GAM's lending portfolio. Now, my lords, that in my submission confuses two different things. Assume for the moment that, as a matter of law, GAM could actually lend up to 25% of $130 million. Let's say that is right. It certainly doesn't follow that in practice it would ever dream of doing so. And if the reality is it would not lend to that level at all, to top whack maximum, then in my submission the statement that there are no differences between banks and GAM about its lending capacity is false. In other words, GAM can't get out of it by saying, well, strictly speaking, I suppose I could have lent up to some very high sum, or 30 million odd. If the reality in practice, as its own correspondent shows, was that it would never have done so. My lord, there is another point, and that is this. The figure of 130,000 Trinidad...
Does it amount to this, that if they had any policy, lending policy, which their lending committee would apply, which would actually make it difficult for the lending committee, or make it unlikely that the lending committee would give permission?
Well, my lords, there may be degrees of likelihood or not. What if it's certain? As good as certain, I would say.
What if it's as good as certain? I see, yes.
I agree if it's a mere possibility they won't, maybe you don't have to mention it.
I suppose it depends upon whether they've made an equivalent known to someone else. We won't have two of these.
Yeah.
They would would they remain open during the intervening period to have made an equivalent loan to someone else, thereby precluding them from making a loan to you, further loan?
Well, they may have done. My lords, I think what's suggested
What,
is
by
that
failing to disclose that their capacity to make a further loan would depend upon whether or not they'd made another loan to a third party in the interim period.
Well, my lord,
that would be a breach, would it?
Well, no, not necessarily, no, my lords. I think, my lords, my position is one has to look at the facts of this case. If GAM had, if I can put it this way, put its cards on the table and said, look, this is actually the position. What we said at the time was, as your lordship is positing, we could have done it, but we, depended on other factors. My lords, we're all well and good. The problem we've got in this case is they didn't say, I mean, all we know is they said in January 2009, we can't do it because of our limited capital base. One draws the inference that was always going to be the case, and therefore they should have revealed that. I accept, my lords, there are all sorts of possibilities. What if it's likely? What if it's certain? What if it's possible? At what point do they have to disclose? I can understand that. But, my lords, what I do, and if they had given evidence, then this point there might be a live issue, as I would put it. But they didn't. And the only inference is they were never going to be in a position to lend up to 24.6 million. In practice. My lords, they gave no evidence at all on the point. Why should my side have to speculate about what the possibilities were, rather than them? My lords, there is just one other point, and that is this, that capital base, what GAM is entitled to do, is to lend up to 25% of its capital base. May I just go to the relevant act? And you see it, I think, in tab 2. It begins at 927 of the record. And section 22, 2I.
This is 927. This is
957. Financial, my lord, forgive me. Financial Institutions Act, 1993. This was the operative act.
Which page are we actually on?
It begins 927, but the relevant page is 957.
Thank you.
Yep.
Subject to this act, banks shall not engage in or carry on any business other than business or banking, etc. And then B, a licensee other than a bank shall not engage in or carry on any business other than business of financial nature. And then subpara 2, a licensee shall not directly or indirectly. Then there are a series of restrictions, and then you eventually get at page 959 to restriction I. Grant secured credit facilities to any one person preceding, that must be a mistake for exceeding, but in the subsequent act they corrected it, 25% of its capital base, or to a borrower, relevant point. So you can't lend more than 25% to one person of your capital base. You then ask, well, what is capital base? For that, you have to go back to page 935 at the top of the page. Capital base means the total of paid up share capital, statutory reserve funds, share premium account, retained earnings, and then importantly, and any other capital account approved by the central bank. So one can't necessarily tell, well, what capital accounts have been approved by the capital bank. My lords, that we just don't know. So I submit one cannot take it that because the 2006 accounts showed a capital base, let us say, of 130 million Trinidad dollars, it follows that that all of that money constituted capital base for the purpose of this definition.
What other capital account could there be?
Well, my lords, I don't know, but we don't have the accounts with us. But the trouble is, this was not a question that was gone into. But my lord, I don't really hang my hat at all on this section, save to say Mr. Ramdean was wrong when he said there were no lending limits. There are obviously some lending limits. But the real point is, going back to my lord's question, it very much depends on what the facts were, but the inference, I say, should be drawn was that it was never in real life possible for GAM to lend up to $24.6 million. That's because they've never said they were able to. despite a barrage, if I may put it this way, of complaints and a failure to deal with the point in the pleadings or disclosure.
Is your case then that what they should have disclosed is the Financial Institutions Act?
No,
The Financial Institutions?
certainly not. No, what they
No.
no, what they should have disclosed was their policies as to what, in fact, they could have lent at any particular time. What they should have disclosed was any documents which went to the question, what is our lending capacity? And that would have been, my lords, one wouldn't bulk at that as
So
a
any internal document?
Yes, any relevant
In the
internal.
public statute?
Yeah, yes, not the statute itself, no. No, but internal documents and communications with the central bank, for instance.
So if you go to a bank and you say, we may need to come back to ask for further money, would they have to disclose then?
No, but they would certainly have to say, they don't have to say.
Well, supposing they said, we'll consider it then.
No.
But in fact, they had a set of policies which affected, or were going to affect, the judgment in due course. Should they disclose? Isn't it for you to ask?
No, not my lords. You have to bear in mind the circumstances here. There is a representation as to the differences between GAM and other banks.
Other banks are going to have lending policies of all sorts. And
No.
they may have a lending policy that is more restrictive than the 25%.
Yes. Well, my lord, my lords, it is not the evidence. It's not the case. It's never been suggested that other banks would have had a similar lending restriction. That's point number one. No suggestion in the evidence whatsoever.
How do we know? I mean, it sounds quite sensible that you don't go near the 25% limit because it's it's an absolute maximum. If you're a prudent bank, you might well have a lower limit. How do we know?
Well, my lord, the reason we know is because we have made the allegation that you told us there was this difference between you told us there were only limited differences between yourself and a bank. Yeah. You did not tell us about your lending limits.
We've got no information, and I've certainly not got judicial notice as to what lending policies other banks would adopt.
Well, my lord,
or not.
Well, my lords, I accept that much. There was no evidence that, let's say, other banks in Trinidad would have been prepared to lend, let us say, 26 million or 27 million. I accept that. But on the other hand, my lords, we made that allegation, and there was no counter-allegation to the effect, well, look, I don't know what you're talking about. This is a fairly normal limit. Well, the question then becomes, if you like, partly a question of burden of proof and inference. We have said, we have made a positive averment that there was this, you didn't tell us of this difference.
You've got to establish that there's a difference between this limit and that an ordinary bank, it links up with causation, that an ordinary bank would have looked at this proposal with alacrity.
Well, my lord, the evidence was that we had been dealing with Republic Bank, and I can't remember whether it in terms says that they were prepared to finance the whole project, but they were certainly...
But I think that's the point that
yes.
Hughes was asking earlier.
Yeah, well,
Yes, it was.
Well,
have I got it right, Mr. Knox? Tell me if I'm wrong, because I'm quite likely to be. But you have to hang the misrepresentation case, don't you, on the only difference?
yes, or differences.
Or differences. Because unless that's raised, you're not suggesting, as I understand it, that everybody who goes to borrow from an institution is entitled to be told what its policies are about future possible applications for extra funds.
No, unless you're very near the limit, maybe. But yes, in general terms, if I ask for a loan, let us say, my lords, there are three possible situations. I'm sorry to duck your question slightly. One is when I just ask someone for a loan, and I don't say anything at all about wanting any further finance. That's one possibility. Obviously, the bank doesn't have to say, well, I can't grant you any more, you know. Another possibility is that I ask for a loan of, let's say, $20 million, which is in fact very close to the bank's limit, lending limits. Let's say the bank's limit is 21 million. I also make it plain to the bank that I would like in due course to come back, or I may well need in due course to come back for further finance. What then? Now, in my submission, it is arguable, but I don't have to get into that position. Arguable in those circumstances, a bank, because I've raised the subject that I want further finance, would be under an obligation to inform me. Well,
What would be the misrepresentation?
it may be a duty. It may be a duty of good faith to warn.
You only get a misrepresentation, don't you, if you make a partial statement, a misleading partial statement.
Or by conduct.
Well, yes.
And the conduct might be, well, look, in the circumstances, by saying nothing on what was obviously an important point to the proposed borrower, by saying nothing, you have led him to believe that there's a possibility that he can get his further.
But in any event, you say you don't have to say that.
Yes, they would have.
Here you've got the conversation about the only difference.
Here you've got the conversation about the only difference. Now, my lords, you say, I understand.
So it hangs on that, and so we get back to the basic
Yes.
point that how do we know there is a difference here?
Well, my lords, can I put it this way? Because it was never suggested, I agree, we didn't adduce positive evidence as to what the banking market was. My lords, one has to be realistic about how these cases are conducted. We didn't do that. GAM equally didn't do it.
Yeah, well, they didn't have to, because the onus is on you to show that there's a misrepresentation.
Well, my lords, that may be right in one sense, but the onus is on us to prove misrepresentation. I accept that. But it doesn't follow from that on every element, that the burden of proof of each individual element is on us. If in fact, one can say, well, it is GAM, who knew things better than we did, certainly would have known what the market was, did not put in a positive case to the effect that, look, other banks
No, I think
would have been subject to the same limit.
That strikes me at the moment as a slightly novel proposition, that the burden of proof shifts according to who may be better placed on the particular evidential scenario to produce evidence.
Well, my lords, you have my submission, but I also rely on the point that one can draw an inference. If that were the case, why did GAM never say so in any of the correspondence, any of its pleadings, any of the evidence? Why didn't GAM just say, look, I don't know what you're talking about. Our limits are the same as everyone else's. We are positively averring the difference. You didn't tell us about this difference. It is not an unreasonable allegation to make. After all, $18.6 million is only £1.86 million odd. The notion that actually banks in Trinidad can't lend much more than that is, I submit, rather strange. My lords, can I mention one other point? It's what a point one often makes in these cases about deference to local conditions and local judges. No one has suggested below, either in argument or in the judgments, that, hang on, banks in Trinidad can't lend more than $18.6 million odd.
If it is the position, if it is the position that other banks have lending limits, albeit that they may be different in terms of size, is it incumbent on GAM to say, we have a lending limit which may be different from other banking institutions?
Well, my case is yes.
Or is it the position that there is a variation in lending limits? There's no obligation on GAM to identify what the differences are or to draw to the attention of the person seeking a loan that theirs may be different from other institutions.
My lords, I would accept that in the abstract. The real point in this case is the facts. We're talking about an equivalent of £1.86 million.
So about the equivalent of
£1.86 million. Yeah. We're talking about a case where this is very close to the limit on the evidence. I submit on the evidence. There's no suggestion in the local courts that banks are limited in that way at all, or in the local or in the correspondence. I submit the inference can properly be drawn that if, in fact, local banks or large banks was the representation we rely on, if there was any such limit that applied to them, we'd have heard about it by now.
Well, that's one way of putting it. But what I think my Lord Mance has put to you is that we can't take judicial notice of what lending limits in other banks might be. I mean, evidence would be required to show that there was a significant difference between the lending limit of GAM and other banks.
My lords, I'm not asking you to take so much judicial notice of some sort of what you might call particular fact. It's not quite that. My lords, you probably can guess what I'm going to say. Supposing it was £400 I mean, no one is seriously saying that everyone's talking about small sums of money. And supposing we're talking about a tenth of this, supposing we're talking about $100,000, £10,000. No one would seriously say you'd need to get evidence, as it were, local evidence, that banks can't lend that type of money on a financing project. So I do submit the very fact that one has to bear in mind the actual facts of the case. This was a relatively small capital base, which GAM appears to have had. It is, I submit, unrealistic to suppose that other large banks or banks had anything like this limit. And that was never an allegation made below. And I do respectfully submit that one has to, your Lordship's board should be realistic. If the point my Lord Mance has been taking and pressing me on was really a good point, how come it's not been taken below? When the probabilities are, it's very unlikely that large banks, or indeed banks, are subject to a restriction of £1.86 million lending on a project.
Are lenders generally forthcoming about their lending policies, limits?
Probably not, I don't know.
Probably quite commercially sensitive, isn't it?
No, but on the other hand, one would know. I mean, there's no suggestion this was a particularly big project.
No, I understand.
or that it's a particularly big sum. I accept.
There is one's got to look at this case in the round and step back for it and ask, hasn't one, ultimately, whether the circumstances in the negotiations in 2007 are such that it's right to treat what was said or not said as giving rise to legal obligations. That's certainly a duty of care point, but I think it's also a misrepresentation point, because it's not every casual statement or non-statement which attracts legal liability. On the face of it, if a borrower is really interested in something as actually abstract and ultimately unhelpful, perhaps, as capacity, because what matters is either a promise or whether the lender, an indication of intention, but capacity is actually no indication as to whether a loan will ultimately be made. And if a borrower in those circumstances really wants to rely on something which they infer about capacity or they're told about capacity by inference, then shouldn't they make it clear and say to the lender, look, we very much hope that you're going to negotiate in good faith for any further lending and so on. Haven't they got to raise it expressly?
My lords, they have to raise it in some way. They did.
Yes, but the question is, I mean, ultimately it's an evaluative question. Did they raise it in a way? Did they raise the possibility of further finance in a way which indicated that it was important to them, that it was something that they were going to rely on, as I say, something as ultimately irrelevant as mere capacity? I mean, I agree, capacity is a stopper if it doesn't exist, but it doesn't, if it does exist, it doesn't say that the loan is going to be made or is likely to be made.
No, not necessarily. I agree with that. My lord, just bear in mind one point. GAM operates differently from a bank in this respect. It can't just offer you what you might call an open facility for drawing up and down. You therefore don't want, and this is in evidence, you don't want, as it were, to take out a 50 million facility, because in GAM's case, it's going to have to lend you all that 50 million facility. So what you want to do is to keep the lending, as it were, but to make it staged. So I'll take 18.6 million now, as it were, and then if I need to come back for more, I'll come back for more. Because otherwise, because GAM can't do it otherwise, you'd have to take all of it all in one chunk. And that is part of the background. But can I also, in answer to your Lordship's question, move on to the next part of my case, namely, why should GAM have realised it was important to reveal this limit about its capacity? And what did my clients say about borrowing further money?
And we're going to look at that very distinctly both before and after the promissory notes were given, presumably.
Yes, yes.
Because the case is, in a sense, quite different legally either side of that date.
It is. Before, it runs in misrepresentation.
Yeah. After it, there may be issues about duty of care and so on, but it doesn't run in misrepresentation.
Yes, exactly. I accept that, my lord, yes. Well, a failure to correct a previous statement, and the obligation to correct it continues, and you're negligent in failing to do so.
But I mean, the straight misrepresentation case has got to operate and work prior to the making of the promissory note.
Yes, I accept that entirely.
And merely because you failed to correct after a contract's made a prior misrepresentation doesn't mean, say, there's a duty of care, does it?
No, not
I
necessarily.
mean, failure to correct is something which exists in contractual terms up to the making of the contract.
But negligent misstatement, my lord, supposing it's a negligent misstatement, I enter into
Yes.
the contract, but then the statement continues to operate on my mind afterwards.
Yes. I can see that.
If you've got a tortious duty, yes. But if it's pure misrepresentation, you are only interested, aren't you, in events before the contract?
Oh, I agree with that. I mean, so, my lord, just to be clear, my primary case-
Including a failure to correct before the contract.
All I'm hoping is you're going to show us the evidence very distinctly either side of that day.
I am, yes. Yes, my lord, I am, yes. My lord, just...
Gam's case seems to me to have been, looking at the correspondence you've been showing us, discussion about differences between us and a bank were only material to a loan of up to 18.5 million, because there was prior to the promissory notes of any desire that we should lend more.
Yes, exactly. And my lord, if that was right as a matter of fact, I accept I've been in difficulties. I accept that.
Right, let's...
So my point is, that is not a correct assessment of the risk.
Yes, right.
And can I come to that? My lord, I deal with this in our written case. I don't want to... I don't want to too much in detail, but it is quite an important part of the case, and therefore I will be looking at the relevant email chains in some detail, just to explain what's going on. And then I hope I can deal with the rest of my case rather more briefly, because there's not so much detail in it. My lords, the position before the loan. And can I just mention what the general context was first, before going to the actual conversations? The general context was this. The project, its common ground, was at an early stage and was going to cost a total of about $60 million to build. And we deal with this at paragraph 39 of our written case. And, we give a number of references to the evidence on both sides, if I can put it that way. Paragraph 39. Oh, 38, forgive me. Page 847. They just put the foundations in. It's common ground between the parties. So we say, well, things at an early stage. That of itself, I don't say is sufficient, but it's the background. Second, my lords, the point I mentioned earlier, the existing loan to which the Deslauriers was subject with the Republic Bank was already about $15.5 million odd. I'll be coming to that in due course. And that's why later, when the loans were actually advanced, about 17 million, a bit more than that, went over to pay off that loan.
And so why do they want to leave Republic Bank?
There was some evidence about it. Essentially, I think one of the employees there, Mrs. Deslauriers, took I can't remember exact details, but Mrs. Deslauriers took the view that he'd rather gone behind her back in relation to dealings on a particular property. So there's a falling out in relation to conduct. I can dig up the reference later. Yeah. In relation to conduct by one of the managers there. I think another issue may have been they wanted the security over Victoria Square, at least over at one point. That was another issue. My lords, another point, just part of the general context. It's clear from the correspondence that my clients told GAM that they were envisaging a long-term relationship. And that's in an email I'll come to, but the reference is record 1, page 89, about 3/4 of the way down the page. So that's the general context. But then one comes to the email correspondence. First of all, in June 2007, and then later in September 2007 before the contract. Dealing first with June 2007. Now, it is plain from the correspondence I'll come to that before the 24th of June, and probably before the 21st of June, there had been a discussion between Mrs. Deslauriers on the one hand and Mr. Ramdeen and Mr. Sancerre on the other. And one can get that, if I may just ask you for the moment to jump into part of an email, in the first part of the record, at page 87. About a quarter of the way down the page.
As we discussed, you mean?
Yes.
Yes.
I need further assistance later on. The security, as we discussed, will be worth a lot more as the buildings actually take. So there's been a discussion. My Lords, while we're on these documents, can I just clarify one point? They're not in colour, I don't think, not in mine.
Which is a pity, but we do. I think we probably understand.
Yes.
Red is the first lot of comments on the 25th, and dark blue is the second, and
Exactly.
and red is in brackets, is it?
Well, red. The only relevant paragraphs you need to know for present purposes. Take page 87.
Yeah.
The brackets would be red. So
Yeah.
that's Mr. Ramdeen, and then blue is after Deslauriers, and all the way down until you get to paragraph 2.
Yeah.
And you have a similar pattern.
Right.
The only other one, my Lords, just for your note, just to clarify, paragraph 8 is an important one.
Yeah.
It's all, as it were, uncoloured until you get to, on page 89, the brackets from a risk perspective, so that's red, and then Deslauriers blue, and she's also saying the other points are fine.
She's blue. She's all the way down to the next page, isn't she? Middle of the next
No,
page.
I think, please consider the above questions, I think is her original email. So the other points we'll find. So that, my Lords, I don't know that, but I infer that because...
So the other points are all fine, is where she stops her
Yes,
intervention,
yes.
so to speak. Yes. Or her 26th of June reply.
Yes, as I understand it, my Lord,
Yeah, I
yes.
see.
I say that because the foot of the page, 89, please consider the above questions would go naturally with the questions asked at 1 to 8 originally.
Yes, I see. And that means that the email has a natural end as well.
Yes. But anyway, the first point I make is there's obviously been a discussion, and that is a discussion in which she is saying the project will be worth a lot more as the buildings take shape. And she's plainly, one infers from that, and indeed from the way it's written at 87, she's raised the point about if I need further assistance later on.
Well, the point about the project being worth more is its potential as security, is it?
Yes, exactly.
To, you would say, GAM,
Yes.
or for that matter to anybody else.
Yes,
Yeah.
or to GAM. But the context of this whole chain of emails is about how much can I borrow, bearing in mind the security I'm prepared to offer.
Yeah.
And that's why we say it's significant. She says, well, of course it's going to get more and more valuable as it goes on, and if I need assistance for later on. But that's the
As literally speaking, as we discussed, is more about the buildings gaining value
Yes.
as they take shape than if I need further assistance later on.
Yes, I agree with that. Strictly speaking, one could read it that way. My Lord, I can't say it necessarily follows, although it'd be odd to have a discussion about the buildings getting more and more valuable without a discussion about,
Well, I don't know. If what you're asking for up front is fairly near the bone, fairly near the loan-to-value ratio, it's perfectly relevant to say, actually, as these buildings take place, you're going to be better and better secured for your existing loan.
I agree. I can't say it necessarily follows. I accept that.
No.
So, my Lord, that's the background. Now, you then have, just taking it chronologically, Mr. Sancerre's proposal is at page 91, at the foot of 91, and he encloses the proposal. Now, my Lords, I've asked, where is that proposal? And we don't know. It doesn't seem to have been put in evidence as an attachment. But we can tell what the proposal was for. And if you go to page 85, foot of the page, Mr. Deslauriers emails, I'm spending some time going through your proposal and would like to respond by taking each point one at a time. One, amount, 15 million. So the amount that's been proposed is obviously $15 million. Now, what then happens is on the 21st of June, you get this from page 91, Mr. Deslauriers replies that she wants 75% rather than 66%. So presumably the proposal was for $15 million, but with this being on the basis of a 66.66% ratio.
Sorry to be behind the curve, Mr. Knox.
Fine,
86, please.
Yeah,
Page 86.
back on page 91, forgive me.
I know you are, but
Yes,
that's why I say I'm sorry to be behind the curve.
not at all.
Could you just briefly glance at 86?
Yes,
Upper half of the page. I have the exact figures from the Republic,
Yes.
on both projects. So here they are. Now this is Mrs. Deslauriers speaking, isn't it?
yes, she's writing.
And what are these figures that she's giving?
These are figures which are the total amount to which is indebted to Republic Bank, and the securities, as it were, on which.
Outstanding.
Yeah, so as I understand what she's saying. So basically, I'm in debt to Republic Bank to $15.5 million.
And she's talking about 21.8 in security.
Exactly.
Right.
I'll explain that in a moment, my lord. No, because I'll explain if I may in a moment. So if you go, my lords, she is replying to the original proposal at 15 million, saying I would like the ratio to be 75%, on page 91. Anyway, we can do that. And then page 90, Mr. Sancerre writes 75% is fine, subject to board approval. Then you get the email as originally written, which starts on page 85, halfway down the page. And if I can just explain what this email says, when you, as it were, ignore for the moment the bits that are interlaced. She's saying, as you go over to 86, the amount is the proposal 15 million. She then says how much she's indebted to Republic Bank, with 15.5 million. Then she goes on to say, I plan to give you 21.8 million in security. And then she goes on to say, well, that at 75% will justify 16.35 million. And then she says there's a difference of 850,000, i.e. between the 15.5 million she's indebted to and 16.35 million, which I plan to use during the interim time to continue operating. So in other words, our 15.5 million will go over to Republic Bank, and that'll leave me with 850,000 clear to continue operating. It's the interim time to continue operating, as this will not be put together until next month. So my question is that if I do this, are you okay with the loan figure being 75% of the equity of the security at 16.35 million? So at this point, she's saying, will you bump it up to 16.35 million, the total loan, not just 16.35. I'll then be using client deposits to operate, as there's quite a bit more than 1.4 million in Heveron Heights. In other words, Heveron Heights is only subject to a 1.4 million security at the moment. But client deposits have been paying construction costs. If I need further assistance later on, the security, as we discussed, will be worth a lot more, and so on. So, my lords, what she's saying there is, I would like 16.35 million, and if I need further assistance, i.e. on top of 16.35 million, I would like, that should be okay, because the security is going to be worth a lot more. Well, I submit that's plainly what she's envisaging. Now, now, forget for the moment the interlacing. She goes on to say, as it were, in the original email, go to paragraph 8, and you'll see what she says about the problem this is going to create for her. She's talking about collateral security here. Paragraph 8, I spoke to Lyndon Scott on the units at Goodwood Park. They're separate from Chamfleur, which would, he said, be 2 million each, so a total of 4 million. That would not be adequate to provide you with 21.8 million security. To do that, I need to give you the 2 parcels in Chamfleur that have infrastructure. So she's basically saying, I wanted to give you 2 Goodwood Park properties, but that's not going to give you enough security. And then she makes some points about being able to sell. But you continue to page 89. She says, so I would want to keep, about 10 lines down, I would want to keep the security to the 2 parcels of land, as Goodwood Park doesn't provide for the value to accomplish my goals. So in other words, by offering Goodwood Park, I'm not going to be able to give you security of 21.8 million. Then she goes on to make reassurances about how she's going to pay. Now, what then happens is, in the replies, you'll see going back to page 87, Mr. Randine's reply on paragraph 1, page 87, he is prepared to put up 16.35 million for consideration. In other words, we can give you that loan. We'd like to look at the valuations and so on. And then, dealing with the question of security, you go to page 89, what he's saying here is, halfway down page 89 in brackets, from a risk perspective, the company would want to hold the GW Park together, either 2 Goodwood properties, with the Chamfleur properties. So in other words, he wants all 4 properties as security if you want to have a 16.35 million loan. So that's how it works. And you can see what the value of those properties is, because one of the, you then go to Mrs. Deslauriers' reply on 87, on point 1, and then she replies to the suggestion of 16.35 million as the loan. We can stick with 15 million. So she comes back down, having suggested 16.3. The last valuation on the main site, which is Heveron Heights Chamfleur, was 40 million. Had a meeting today. The actual is now 16 million. And then she goes on to say, so that's one. And then the second site, that Chamfleur, is 7.8 million, done recently. Goodwood Park would be 4 million. You therefore would need 20 million to do the 50 million loan, which would be the main site in Goodwood Park, i.e. 16 million plus 4 million. So she's basically saying, look, let's drop the second Chamfleur site. We'll just do the bigger one at 16 million and the 2 Goodwood sites. I'm prepared to give you that as security. And that will give me 20 million security, which gives me the $15 million loan. And that's what's going on. And then, likewise, you then go to page 89, halfway down the page, Laird Deslauriers, in answer to the question about holding all 4 securities, all 4 properties, she says, not a problem, but whatever you hold, I would expect to have access to 75% if needed. Obviously, I would only access it if needed to keep interest down, but would like to have the ability to do so if I had to. Is that acceptable? So she's there saying, well, I want 75% of whatever you hold. Now, I'm not going to necessarily do it because she wants to keep interest down. So, in other words, she wants to do this. My lord, what she appears to be envisaging is she would have access to the secured facility to borrow, so she doesn't have to borrow unsecured at greater rates elsewhere. But the important point is, she's saying here, I want up to 75%, please, whatever you've got.
And is this going over 16.5, or is this just a discussion about the gap between 15 to which she's returned and possibly going up to 16.5?
Well, no, in my submission, she's going further, because actually, if all 4 properties were held, that's 4 million plus another 16 million plus about 27.8 million. So she'd be saying, my lord, one way of reading it is this. You'd say, she's saying, well, I want access to security, access to lending on the basis, if you have security of 27.8 million, I want access to 75% of that. Another way of reading it is, I just want access to 75% of whatever you've got, taking into account the increase in value as time goes on. Now, my lords, I accept you could read it either way. I should say in the Court of Appeal, Mr. Keeley's predecessor read it the way I contended for, but that may not be the most important point.
So what is the ultimate position, and where is that defined?
Well, my lord, one then has to go to the email. You see at page 84.
At 84?
84, which is the email under cover of which she sends back her blue comments. Do you have that, my lord?
I got that, yeah.
I answered your points in darker blue. Everything seems fine. We just have to figure out how to structure things. I want to put the VS loan in one package, that's the 12.4 million, and leave it for 1 year, you would have 20 million for that. It should be as security, I think. I also have to construct the project. And my lords, then she says in terms, I will need backup financing, just in case.
Yeah, but that depends from whom.
Well, my lords, I submit obviously from GAM, the second site of 7.8 million will be adequate for now. She's now talking about the second Chamfleur site at 7.8 million, which has been taken out of the security offered for a 15 million loan. The second site of 7.8 million will be adequate for now, along with the client stage payments. So would we do a second loan for that? If yes, does the year begin when I make my first drawdown? So if I draw 100,000 and then continue to make draws, can I pay it off on the first try? So she's basically saying, she's envisaging that there'll be the 15 million loan with 20 million security, and then another loan with 7.8 million security. And she's asking, how are we going to work that other loan? And she continues, my lords, third paragraph, fourth paragraph, they have redone, this is Republic, their proposal omitting Victoria Square now, seeing that wasn't an option, not that it ever was. However, they're saying they will not extend any more financing until I sign their proposal and accept it. And then she talks about Chinese families and so on, but she says I might have to accept it. The proposal allows me the ability to pay off the loan at any time with no penalties. This gives you time to have your board meeting, get the necessary approvals. I would like to sit with you at some point in the next week or so to show you the cash flows and see how we can structure the whole thing. I assume, as you said, that once the site reaches the building, you will release additional security. Now, my lords, I submit a fair reading of these emails is this. She is on any footing raising the point that I might need further financing in addition to the loan which was initially put at 16.35 million.
Right. Can you point to anything which constitutes anything at this stage by way of acceptance of
Certainly
that or agreement to it?
No, I'm not.
No.
My point is simply this. This possibility was raised. I might need further finance later, in addition to the 16.35 million or the 15 million we're now talking about. And she's certainly raised on one footing the question, the prospect of this being, I want up to 75% of whatever you hold at the time. And I submit that of itself, all this of itself shows that the possibility of further financing in addition to 18.6 million was something which she raised with them. Well, I say 18.6 million, certainly 16.35 million, was something raised with GAM. And therefore, if there are going to be problems about lending much more than that, they have to tell her in a conversation about the differences between themselves and the bank. That's what it comes to. My lord, the second chain, my lords, if I can just very briefly take you to this. The September, again before the contract chain, is at page 102. And at the foot of the page, my lords, what has happened is that by now a proposal has been made. And it rather oddly seems not to have the right securities in it. And so you can find that, you see that from 102, paragraph 4, at the end of the page, near the end of the page. This is an email from Mr. Deslauriers. The security mentions the 2-acre site, Chamfleur and Goodwood Park. So just one of the sites, in other words. Are you saying this is enough? The 2-acre site's worth 7.8 million, so they've gone and put in the second site. And what did you value Goodwood Park at? Then she talks about the value. And then these two properties probably cover the collateral. Do you also need the 4-acre site? If that alone can cover the collateral, please clarify. And then GAM reply, the security presented to the board was Heaven Heights, the 2-acre site, and Goodwood Park, as we discussed.
Heaven Heights is 4 acres, is it?
Yes. Yeah, they're both Chamfleurs, Heaven Heights, 4 acres. Looking at the terms, I am not seeing Heaven Heights, so this has to be... So in other words, GAM is saying, oh, it looks as if we've missed out Heaven Heights by mistake. And then,
sorry, where are you reading from, Mr. Knox?
Oh, sorry, the foot of 102. Looking at the terms, I am not seeing the Heaven Heights, so this has been an oversight. So he says, oh, I see we've gone and missed out one of the securities, in fact, the most important security in our offer.
I'm afraid I don't see at the foot of 102 looking at the security.
Paragraph 4.
Oh, I see. This is her saying.
Mm-hmm.
Well, it's the bracketed bit is GAM in answer.
Oh, I see. Yes, yes, I'm with you.
But one of the difficulties reading these email chains is that you have to know how the interlacing works.
Yeah. Oh, I see. That's helpful. Yeah.
So she's saying, goodness, you don't seem to want all that as much security as I thought you did. They say, oh, look, we've made a mistake.
Yeah.
You then go up the page to the top of 102. Mr. Deslauriers replies, spoken to the valuer, he's valued Heron Heights at $17 million, so it's 17 million now. The units at 2.1, and so on. Hope to drop off that. So in other words, one Chamfleur's site is 17 million. Then over the page, sorry, 101 rather, back a page. Mrs. Deslauriers writes near the foot of the page, about 3/4 of the way down, just confirm you have everything from me, right? As you see, land is now valued 17 million. We'll be escalating to 80 million. Shouldn't one just be enough? To which Mr. Ramdeen replies, basically he wants A, the 17 million site, plus also B, the other parcel to meet the loan to value requirement. As I know you didn't want to give Goodwood Parks. In other words, I want both Chamfleur sites. So 17 million plus 7.8 million. So this is what, and then Mrs. Deslauriers replies halfway up the page, that's fine, you'll be holding 24.8 million. Does that mean I've got access to 18.6 billion, 75% if needed? If yes, I'll stop by. Yeah. So that's how it gets up to 18 million, 18.6 million. And then you have the email on which I do rely, which is Mr. Ramdeen himself saying, well, in other words, it means that if you need up to 18.6, then it shouldn't be a problem from a loan-to-value perspective. My only constraint would be, if I disperse an additional amount, I would have to run that additional amount for at least a year to ensure it's with my qualifications.
Yes, but, sorry, now where exactly is that?
Oh, sorry.
Oh, I've got it.
Going upwards.
Within my guideline.
Yes, yes. But then, that's the additional amount taking you up to 18.6, isn't it?
No, in my submission, no.
Isn't it? Because she's saying, well, you've got 24.6 collateral.
Yes.
Against a discussion which is then about something less than 18.6. And she says, does that mean we can now add on a bit more and go all the way up to 18.6? To which he says, well, yes, if you want to go up to 18.6, but then it's got to be for a year.
Well,
so we can't trickle fund it.
Well, my lord, in my submission, well, my lord, you have my submission. I submit the correct construction is otherwise. She's saying, can I have access to about 18.6? And he's saying, well, yes, you can, but if you want more, because she has raised before the prospect of 80 million being collateral.
No, she's not discussing anything over 18.6, is she? I mean, the whole discussion is about up to 18.6.
Well, look at the answer, Mr. Knox, immediately above it. Sunday the 9th, 12:37.
I accept.
So, then if we do the 18.6, I have to do it now.
Yes.
So,
I accept that's what she takes it to be, but my lord, anyway, my lord, you have my submission.
Oh,
if she takes it to be that, isn't that the end of the matter? No. You can't rely on a misrepresentation.
No.
Perhaps we ought to take it at that. Resume at 2 o'clock. You're doing all right, are you?
I think so, my lord, yes.
Yes, thank you very much.